criminal breach of trust is one of the offences against property provided under Chapter 17 of our Malaysian Penal Code. So in general, breach of trust happens when someone who has been entrusted with a property, but then he fails to fulfill the duty given to him, so he has committed breach of trust. So in this context of criminal law, we have the main provision of this offence, which is under Section 405. So let's move on to the main provision of CBT. So this offence provision in Section 405 has laid down the circumstances which can amount to CBT. So we have divided this into three parts. The first one is a precondition, second one is the physical elements, and the third one is the fault element. Okay, so for the precondition, it mentions that whoever having been entrusted with property or having dominion over the said property, either alone or jointly, so he can be charged under this offence if he fulfills the physical elements and also fault elements of this provision. So let's look at the actus reus of this offence. So we have five elements which can be extracted from this offence. The first one is misappropriation, second one is conversion, the third one is use or disposal in violation of law, and fourth one, use or disposal in violation of a legal contract, and the fifth one is suffering another person to do any of the elements mentioned in 1 to 4. Let's move on to the fourth element or mens rea for CBT. So dishonesty covers cases from 1 to 4, which are misappropriation, conversion, use or disposal in violation of law or legal contract. On the other hand, willfully is the mens rea that covers cases whereby a person who has been entrusted with the state property, but then he suffers another person to do so. So so the liability can also be imposed on that person. So further elaboration will be given by Genevieve. Thank you.
Today I'm going to talk about the element of CBT. The first element of CBT is the existence of trust. The degree of control exerted by the accused is the most important issue to consider. Merely control is insufficient since a person who has been entrusted with property will show the signs that they are in possession of it. This can be seen in the case of Signatory versus PP. Besides that, the existence of trust appears in any manner. It is not required that the trust to be established as an outcome of a legal object. In the case of R versus Tang R said that the court found that the money could be retrieved by a complainant at any time before the illegal purpose was carried out. In addition, the existence of trust exists when entrusted with property or having the dominion over the property either solely or jointly with any other person. In Malaysia, partners will be convicted of CBT for joint property. This can be seen in the case of Haji Sahid versus SHAH, and the court held him guilty of criminal misappropriation and emphasized that it's important to protect the honest partners against dishonest partners. Turning now to the physical element of CBT, which is the actus reus, the term misappropriation and conversion bears the same meaning as they do for criminal misappropriation. Next is dishonesty used or disposed of property in violation of any direction of law prescribing the mode in which such trust is to be discharged. A direction of law will be violated if the accused breaches specific legal obligations imposed on the executor of a will, regulations governing the use of money by the public servant, and the law with respect to contribution to employee provident fund. This can be seen in the case of PP versus Regan Samida. Next is the use or disposal of property in violation of any legal contract, express or implied, which the accused had made to touching the discharge of the trust. In Mumini v. Haji Muhammad Taha versus public prosecutor, where he can be liable because as the paymaster he is responsible for managing the wages of the army in that camp. His failure is in violation of the contract of service. On top of that, the physical element can be extended to willfully suffering another person to do any. The court emphasized on the actus reus in public prosecutor versus Yong that a manager who is entrusted with a customer money might be found guilty of CBT if he knows his clerk has misappropriated his client's money but does nothing to stop his clerk. Now coming to the fourth element of all the CBT cases is dishonesty. According to Section 409B in Malaysian Penal Code, if the prosecutions have proved entrustment and either misappropriation or use in violation of law or contract, the accused is presumed to be dishonest until the contrary is proved. Hence, Malaysia has reversed the onus of proof for all the cases. In Navaratham versus public prosecutor, where a prison official was found to have taken the money belonging to the prisoner whose possessions had been entrusted to him. He said that he intended to use the money to pay a lawyer for the prisoner. Since the prosecution had not produced evidence to rebut it, he was acquitted. The fourth element for suffering another person to do any physical element mentioned before is willfully. In the case of Yong Fu Yuan versus R, the first accused was charged with willfully suffering the second accused to dishonorably misappropriate some of the money from the union fund. The second accused was charged for everything with the CBT. That's all for me. Now I'll pass the floor to the next presenter. Thank you.
Now I will be explaining on the punishments of criminal breach of trust provided in our penal code, starting from section 406 until section 409. So the general punishment for CBT in section 406 states that where the accused person who committed a criminal breach of trust is punishable with a jail term up to 10 years and liable to fine as well as whipping. So furthermore, it is noteworthy to point out that the punishment differs and varies depending on the persons who committed it. It depends on the categories of persons who performed it, right? So for instance, section 407 of Penal Code provides that for the CBT by carrier, wharfinger or warehouse keeper, where they have the responsibility as a transporter of things, so when they have been entrusted with the property but then they later on breach the duty, they shall be punished with imprisonment starting from 1 year up to 10 years imprisonment for the maximum term, together with whipping and also fine. Right. Moving on to section 408 of Penal Code, where anyone who is employed as a clerk or servant who has the capacity to be entrusted with such property or they exercise some dominion over it, so they can be imprisoned for a minimum term of 1 year up to 14 years if they are found to be liable for criminal breach of trust, and they are also can be charged with this section together with whipping and also fine. Last but not least, we have section 409, and whereby this section holds the biggest liability for public servant and agent, whereby the minimum term of imprisonment is 2 years while the maximum term for imprisonment is 20 years together with fine and also whipping.
Criminal breach of trust offers comprehensive advantages that are able to secure the nation's conquered from being tainted by the widespread of felonies. One of the advantages of CBT is to prevent fraud. Fraud can be understood as dishonestly making a false representation, followed by the intention to gain or to cause loss. As stated by Sridhara Nair, managing partner of PwC Malaysia, fraud is seen to be one of the biggest threats to business, as business misconduct and asset misappropriation becomes the regular practice in their daily business activities. Reflected in the case of Datuk Haji Harun Idris against PP, which one of the charge was against Appellant 1 and Appellant 3 under Section 109 and 406 for abatement of criminal breach of trust. The issue was whether the second appellant act of dishonestly misappropriated the shares that had been entrusted by the bank falls under Section 405 of the Penal Code. By applying the definition and the elements to invoke the said offence, the court held that it was sufficient for the prosecution to prove that the second appellant had dishonestly misappropriated to his own use of the shares entrusted to him, or that he had dishonestly used them in violation of the law and the contract of service prescribing the mode to discharge the trust. CBT also offers an advantage in reducing the high rate of corruption. As we all aware, corruption in the country impairs the economic developments and distorts healthy competition, as the economy only revolves around illegal activities. As said by Datuk Sri Azam Baki, the Chief Commissioner of MACC, Malaysia made an impressive progress in a battle against corruption. One of the milestones reached is by pressing charges against the former Prime Minister, Datuk Sri Najib Razak, for criminal breach of trust. In this case, the accused was charged with 3 charges of CBT as a public servant and agent of the government, namely the Prime Minister, the Finance Minister and SRC Advisor Emeritus for misappropriating 42 million in 2014 and 15. Based on the evidences presented, it was held that Datuk Sri Najib had complete control over and was a shadow director or director of SRC. This indirectly fell within the definition of agent under Section 402A of the Penal Code. The learned judge sentenced the accused to 10 years for each 3 charges under Section 409 for CBT. Lastly, CBT also enables professionals to preserve its dignitary reputation because professionals are not excluded from the CBT liability, which prevents them from breaching their professional duties. This can be seen where a former lawyer was sentenced to 9 years imprisonment for CBT on the stakeholders' sum totaling approximately 60,000 ringgit, involving the money from a house loan paid by the Hong Leong Bank.
So now I'll be presenting about the loopholes or limitation of criminal breach of trust. So criminal breach of trust by willfully suffering is regarding the accused person permitted the third party to act dishonestly over the property the accused person entrusted with. So even though the third party is not free from any liability, he can be charged with abetment. There is an issue and question arise regarding this element, because it is important to note that there is a presumption in which the accused person to have been dishonest until the contrary proven. If the prosecution has proved entrustment and either misappropriation or violation of law or contract, it is called the reverse onus of proof in all the cases. for the criminal breach of trust. So, however, the issue here is that there might be a possibility that the interpretation will criminalize those who consciously allow a third party to use their property in a certain way, even though they are unaware of the circumstances that will make the third party's action lead to a crime, as in the unlawful acquisition or the deprivation of the property. So, the term willfully suffering indicate the need of the evidence in which the accused person was aware of the third party's dishonesty. So, based on the subparagraph 3 of the section 409B, if it is proven in any proceeding that any person entrusted with property or dominion over the said property caused any person to commit any of the acts listed in the subparagraph 1 or 2 in the said section, it is considered that he acted dishonestly until the contrary is proven. So it is shown that the accused person now will have to prove his innocence, and if he fails to do so, he will be found guilty. But now, in order for the accused person to prove his innocence, might need the evidence in which the accused person was aware of the third party dishonesty. But there isn't any explanation of which constitute the dishonesty of the third party, because there should be a right way or procedure in the handling the involvement of the third party in the criminal breach of trust, in which it needs more explanation in terms of the procedure or legislation in this section for the third party. Because instead of focusing the offence on the accused person, the same treatment should be given to the third party as well. Because instead of focusing the offence on the accused person, the same treatment should be given to the third party as well in determining the intention or act of the third party in this case, whether it is considered dishonest or not. But there isn't any explanation or which constitute the dishonesty of the third party. So how the accused person gonna prove his innocence if there isn't any explanation about how to prove the dishonesty of the third party? It is equally important to establish the liability of the third party against those who assist in the offence of the criminal breach of trust.
Hello everyone. So right now, I will be talking about how to improve the law of CBT. As you can see, this is the main provision of CBT under section 405 that has been explained by my groupmates earlier. Other than that, it is essential to prove dishonesty for the first element in criminal breach of trust. This is because, until the contrary is proven, the accused is presumed to have been dishonest, as being mentioned in section 409B. However, the issue arises on the part of a third party as to whether the act and the mind of a person can be regarded as dishonest, or whether the act alone is regarded as dishonest. The issue arises as there are no clear and specific explanations for the dishonesty on the part of a third party. Therefore, an improvement can be made to strengthen the law of CBT in order to answer the issue pertaining to dishonesty. Firstly, the court should apply a reasonable man test. This test was to determine whether the third party did or did not do something that a wise and reasonable person would do or not do. Moreover, it is a fairly common principle which inquires into how an ordinary person would have acted under the circumstances presented at the time of the alleged offences. It can be referred in the landmark case of Barnes against Eddie, where Barnes' children filed a lawsuit against Eddie and the solicitor because the trustee misused the trust property and went bankrupt. It was affirmed by the court that the claim against the solicitor was dismissed on the ground that there are two liens that may result in third-party liability for breach of trust, which is known as knowing receipt and knowing assistance. So what is knowing receipt and what is knowing assistance? Knowing receipt is when those agents receive and become chargeable with some part of the trust property, while knowing assistance when they assist with knowledge in a dishonest and fraudulent design on the part of the trustees. Ultimately, the solicitors in Barnes against Eddie were found not liable as they did not have knowledge of the breach of trust. Thus, the reasonable man test can be used in order to prove dishonesty as one of the five elements of CBT, in which it must be a fraudulent and dishonest infringement. Hence, without dishonesty and fraud, an element for criminal breach of trust will not be sufficient to prove the offence as being ruled in the case of Barnes against Eddie. Moreover, it is further illustrated in the case of Selangor United Rubber Estate against Credok, where the third party who were involved in CBT are now liable for the offence. In this case, it involved the misuse of company funding by means of a scheme in which the purchaser had bought the company by using the company's own funds. The third party were a bank that deposited funds in the purchaser account and assisted the purchaser in using these funds to acquire the company. The court held that a reasonable banker was able to assume that the money was intended to finance Mr. Craddock's purchase of the plaintiff company share by applying the objective test.